Hello, my name is Tim McCurdy, and I am a guardianship attorney practicing in St. Louis, Missouri. Today we're going to be talking about who can be appointed guardian in Missouri for someone who has been found to be incapacitated. What does that mean? In Missouri, a guardian is someone who is appointed by the court to manage the affairs of someone who has become incapacitated. Incapacitated is a legal definition, meaning that the person can no longer either decide what they want in terms of where they live or what doctor they're going to see, or they can't communicate their wishes to where they need someone else to step in and do that for them. Someone can also be appointed a conservator in Missouri for a disabled person. And the way to think about that is the guardian is the person who makes decisions about where the person's going to live, what doctor they're going to see, and the conservator is the one who manages the money and of the person to pay those bills or to track the finances. Oftentimes in Missouri that's going to be the same person. The guardian and the conservator can certainly be the same person fulfilling both roles, but then the question becomes, who is going to do that? How is that decided? And the court is going to decide who is going to serve as the guardian for the individual who is incapacitated. And when the court is doing that, the overall standard that the court is going to apply, and as they're making any decision, is going to be what is in the best interest of the incapacitated or disabled person. The court, though, isn't able to just simply use its own discretion completely and decide who that's going to be. The court, by law, when we're dealing with an adult who is disabled, is required to follow an order of priority. So that means that the court has a list that they have to go through and look first at the first category and say, is there anyone in this category that could serve in the best interest of the individual? And if they are, even if there's someone else down the line, they say, well, maybe that would be a good person too. By law, they're required to follow that order of priority. So what's the order of priority? First is going to be if the person can express who he or she wants to serve as their guardian. Now, oftentimes, because of the disability or the incapacity, the person isn't going to be able to tell the court, this is who I want to be my guardian. And so this might not be an option, but if they are able to, the court is going to look to that first. Second, the court will see whether or not the individual has nominated someone in a power of attorney. So this would be a document that was created before the person became disabled, where they have said, if I ever become disabled or incapacitated and I need a guardian, this is who I want to serve. So if you think about it, it's first, can the person tell us who they want? And second, have they told us already in a power of attorney before they became disabled, this is who I want to serve? Third, the court is going to look to see if there are any family members who can serve in the best interest of the person. And so they're going to look to see, are they married? Can their spouse serve as guardian? Do they have parents or who are still living and able to serve as guardian? Close family, brothers and sisters, to play that role, but in the best interest of the individual. And fourth, is there anyone else who is named in the will? Anyone who's been identified by this person before they became disabled to say, this is someone who's close to me, this is someone who could serve as my guardian. And you see that in all of these levels of priority, the law is focusing on the wishes of the individual, and if they've nominated anyone or if there's anyone close to them and their family who could serve. And the reason that they go through that priority is because they want to make sure that the last resort, if there's simply no one else, is going to be the public administrator. The public administrator is a government body that serves as kind of the guardian of last resort. If there's no one able to fill that role, then there is a government agency that can serve as guardian. And keeping in mind that the public administrator is going to be guardian for hundreds, if not thousands, of people. And so the goal of the law is to make sure that, if possible, we're nominating someone that has been picked by the person or as a close family member, as opposed to having to have the government essentially serve as the guardian for the individual. I hope you found this information to be useful. Please keep in mind that this is general information that can help you if you are deciding to pursue a guardianship. To keep in mind that it's 2 steps. First, you have to show that a guardianship is needed, but also you need to think about, would I be the person to be appointed if the petition is successful? But keep in mind that this is general information. If you have questions about your own specific legal needs, please feel free to give me a call, and I would be happy to answer any questions that I can. Thank you.